Good morning, Vande Mataram, Jai Hind. How are you all? I hope you have watched the previous videos before watching this video and subscribe to channel and click on the bell icon to get the notification of new videos on time. Today we are going to learn about the fundamental rights, part 3 of the Indian Constitution and Article 12 to 35. Day 5 of Indian Polity. So without wasting time, let's start. Fundamental rights have been described as the Magna Carta of India, that means the core part of Indian Constitution. The concept has been taken from the US Bill of Rights. This fundamental right has been taken, the concept for the fundamental right has been taken from the USA. Earliest known evidence of the right was also present in the ancient India, Iraq, etc. Fundamental rights are named so because they are guaranteed and protected by the Constitution, which is the fundamental law of the land. They are fundamental also in the sense that they are the most essential for all-round development, material, intellectual, moral and spiritual of the individual. The fundamental rights has been mentioned in part 3 of the Indian Constitution, and the Article 12 to 35 deals with it. The concept of the fundamental right has been borrowed from the Constitution of USA. So basically, Magna Carta of India, that means the core part of the Indian Constitution, is described as the fundamental right. The fundamental right concept is taken from the USA Constitution. The next is, there are few fundamental rights. They are right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational right, right to property. It has been repealed by 44th Amendment Act 1978. Right to constitutional remedies. That means we have 6 fundamental rights. So we will discuss each one by one in details. So Article 12, definition of the states, means the Article 12 describes about the term state of the purpose of fundamental right. It includes the government body and the Parliament of the India, and the government and the legislature of each of the state, and all local and other authorities within the territory of India or under the control of government of India. That means under Article 12, the definition of the state, that means the union government and the state government, is given. Then in Article 13, laws consists with the part 3 or the fundamental rights. That is, first is inconsistent laws. Article 13 provides for protection of fundamental right. It gives the protection to the fundamental right which were provided by the Indian Constitution. There are some voids in it. Any law which violates fundamental rights would be unconstitutional, that is invalid or legally not binding. Our Constitution place fundamental rights on a higher pedestal, and hence the Constituent Assembly impose a restriction on the Parliament from making laws which violate rights part 3 to be void. That means this Article 13 gives the fundamental right as the upper hand over the Parliament, that Parliament cannot avoid the fundamental rights while making any laws or policies. Then the first, the right to equality. In this there are 2 parts. Right to equality comes under the Article 14. There are 2 parts: equality before law and the equal protection of laws. The equality before law is taken from the British origin, and the equal protection of law is from the American origin. In equality before law, it means that no man is above law. Every person, whatever be his or her status or rank, is equal to the eyes of law. That means in eyes of law, each and every person of the Indian citizen is equal and no one is above the law. Equal protection of laws, that means it means that the like should be treated alike. That means every person will be treated as the same without any priority. Equal protection of law, each one will get the same laws. The state cannot treat unequal people as equal, apples, oranges are not the same. Thus, it gives freedom to mandate the state to make special provisions for disadvantaged sections of society. For example, the affirmative actions laws, special laws for women and children, etc. That means if there is any the disadvantaged sections of society, then state or the central can make the laws and the policies for the development of them. Then comes the Article 14. Article 14, I have already described it. The state shall not deny to any person equality before the law or the equal protection of law within the territory of India. This gives the clear picture of the equality and the equity. This one. Then the equality means each and every person will get the same benefit, but some sections require more benefit than the other section. That means the equity. Then comes the Article 15. Article 15, prohibition of discrimination on the grounds of religion, race, caste, sex or place of birth. That means the Article 15 gives the protection on the discrimination. If anyone is discriminating anyone, then I can file a complaint over that person. The state shall not discriminate against any citizen on the ground only of religion, race, caste, sex and place of birth or any of them. No citizen shall on the grounds only of the given suggestions or the given conditions shall not discriminate. Nothing in this article shall prevent the state from making any special provisions for women and children. In short, the Article 15 prohibits the discrimination on the grounds of religion, sex, caste and place of birth. This is given in the Article 15. Then comes the Article 16. The Article 16 in short deals with the equality of opportunity in matters of public employment. That means in public matters or the government sectors, each one will get the equal opportunities. There shall be equality of opportunities for all citizens in matters relating to employment or appointment to any office under the state. No citizen shall on grounds only of religion, race, caste, sex, descent, place of birth, residence or any of them be ineligible for or discriminated against in respect of any employment or office under the state. That means everyone in the who is a citizen of India will get the same benefit or same opportunity for the public employment. For this, there was a one Mandal Commission appointed by the Morarji Desai under the chairmanship of B.P. Mandal for this article to investigate the condition of social and educational backward classes, although suggest measures for their advancement as well. Report was submitted on 1980. 3743 seats were reserved for the backward classes. This is the Mandal Commission for the equal opportunities in matters of public employment. Then comes the Article 70. Many of the time this has been asked in the exam. What is the Article 17 or the abolition of untouchability is given in which article? So Article 17 deals with the abolition of untouchability. The untouchability is the abolished and its practice is any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with the law. The untouchability means the छुआछूत जो होता था पहले किसी व्यक्ति जो अगर बैकवर्ड क्लास से होगा तो उसे छूना मना था, वही इसको अब Article 17 completely abolished that, and any person who is doing it is a punishable offence in accordance with the law. Then comes the Article 18. The Article 18 deals with the abolition of titles. That means in Article 18 clause 1 prohibits the conferment of titles, military and academics distinctions are excepted from the prohibition. Clause 2 prohibits a citizen of India from accepting any titles from the foreign state. That means if I am a citizen of India other than the military or academic distinctions, apart from that, if I am a normal citizen, then I cannot get the titles from the foreign states. Clause number 3 states provides that a non-citizen who holds any office of profit or trust under the state shall not accept without the consent of the parliament any title from any foreign state. Article 4 deals with no person or citizen or non-citizen holding an office of profit or trust shall without consent of president or accept any present or emolument or office of any kind from or under any foreign state. If a person, a non-citizen, if he is doing any job or employment that is the office of profit or trust, he will not get any kind of titles, the emolument or the office from the foreign state without the prior consentment of the president. This was the under Article 14, the abolition of titles. Then comes the Article 19 to 22. It deals with the right to freedom. We have given the right Article 19, that is the sixth freedom to citizens. What are they? Article 19A, freedom of speech and expression. Then the 19(1)B, freedom to assemble peacefully and without arms. 19(1)C, forms, association, union or cooperative societies. 19(1)D, freedom to movement. 19(1)E, freedom of residence and settlement. 19(1)F, deleted by the 44th Amendment Act, that was deals with the professions. 19(1)G, practices any profession, occupation, trade or businesses. That was all under the Article 19, the sixth freedom to citizens given, right to freedom. Then comes the Article 20. Article 20 deals with the protection in respect of conviction for offence. In that there are three subclause. One is no ex post facto criminal legislation, no double jeopardy, no self-incriminating evidence. And the Article 21 deals with the right to life and the personal liability. 21A deals with the free and compulsory education. 22 deals with the protection against arbitrary arrest and detention. Under that, Article 22(1) deals with the informed grounds of arrest. 22(2) produced before nearest judicial magistrate within 24 hours. We will learn one by one, starting with the Article 20, protection in respect of conviction for offence. That means if you are getting arrested, then you have some provisions, you have some protection in respect to conviction for offence if you have done any mistake. No person shall be convicted of any offence except for the violation of a law in force at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of commission of the offence. If any person is convicted any offence, that means any person has done some mistake, then he will, and he violated the law which is enforced in that particular area, then he will charged as an offence which has been given under the law book and not more than that. Then the second is, no person shall be prosecuted and punished for the same offence more than once. That means if I am punished for one offence, then I am not applicable for the double for the same mistake. If I am done one mistake and I get the punishment for that mistake, then again the law is not allowing for the giving me the punishment for the same mistake again and again. I have got the punishment, that's it. If I done the same mistakes again, then they can punish me for the same. No person accused of any offence shall be compelled to be witness against himself. That means you are not witnessing yourself. Then the Article 21, the protection of life and personal liability. That means no person shall be deprived of his life or personal liberty except according to the procedure established by law. That means you have some provisions for the protection of your own life and personal liberty. There was two cases, Gopalan case 1950 and Menka case 1978. Menka case deals with the protection of herself from the in the office, the harassment. The Article 21 deals with the use of four crucial expressions that are life. As here use something more is meant than mere animal existence. The inhibition against its deprivation extends to all those limbs and facilities by which life is enjoyed. The personal liberty in Article 21, it is widest amplitude and it covers a variety of rights which go to constitute personal liberty of man, and some of them have been raised of status and distinct fundamental rights and the law and the procedure established by law. That is given in the Article 21. And also the expanded scope of Article 21 has been explained further in the case of Unni Krishna versus the state of the Andhra Pradesh. In the case, the court provided the list of some of the rights covered under the Article 21. Some of them are: first one is the right to go abroad, the right to privacy, the right to education, the right against the solitary confinement, against the handcuffing, against delayed execution, the right to shelter, right to livelihood, right to health and medical aid, the right against the custodial death, the right against the public hanging, and the doctor's assistant. These are the covered under the Article 21. Also, there are some few more. The Article 21A deals with the right to education. That is, every child has the right to free and compulsory education of the group of 6 to 14. That means the age group between the 6 to 14 years will get the compulsory free education. The education of fundamental rights in India, it's covered in the DPSC. We will discuss about it later verse. Then the Article 21, we have discussed about it. Then the Article 45, it deals with the state shall endeavour to provide early childhood care and education for all children until they complete the age of 6 years. That means until the age of 6 years, the state will cover the early childhood care and the education. All the money required will be given from the state. The Article 51A, in that K, deals with who is a parent or guardian to provide opportunities for education to his child, or as the case may be ward between the age of 6 to 14 years. That means before 6 years the state will give the early childhood care and the education, but after the 6 to 14 years it's the parents or guardians duty to give the opportunities for education and the all required care. Then comes the Article 22. The Article 22 deals with the protection against the arrest and the detention in certain cases. It covers gives the protection to arrest the person against arrest and detention in certain cases, within which it ambit contains very valuable element of natural justice. In that, Article 22 1 and 2 confers four following fundamental rights, that are: right to be informed as soon as may be of the grounds of for such arrest. That means if you are getting arrested, then you have to know why you are getting arrested. That is covered in the Article 22(1), right to be informed. Then the right to consult and to be defended against the legal practitioner of his choice. That means if you are arrested, then you have a right to consult with the law officer or the legal practitioner. Then the Article 22(3) deals with the right to be produced before the nearest magistrate within 24 hours of his arrest. That means if you are arrested, then you have to right to produce before the nearest magistrate. That means the judge within the 24 hours. Then the right 22(4) deals with right not to be detained in custody beyond the period of 24 hours without any authority of the magistrate. Before after 24 hours you are not allowed to be detained in the custody without any authority of the magistrate or the judge. Then the Article 23, right against the exploitation. Right, Article 23 deals with the prohibition of traffic in human beings and forced labor. That means trafficking of human beings and forced labor. That means there are some cases where the human organs or the entire human is kidnapped and transported to the other places for the slavery or other uses, and also the forced labor without any his or her intention for being treated there. For this, Immoral Traffic Prevention Act is there 1956. For Labor Beggar Bounded Labor System Abolition Act, Minimum Wages Act 1948, Contract Labor Act 1970 and Equal Remuneration Act 1976 are there. The Article 24 deals with the prohibition of employment of children in factories. The children are not allowed to work in any factories who are below age 14 years. The law passed by the Parliament is carrying out of Article 23, suppression of immoral traffic in women and children, and 1956, Bounded Labor System Abolition Act 1976. There is also one act, Child Labor Amendment 2016. Before this, the children who are below 14 years are not allowed, but after these, below 18 years are not allowed to work in any factories. These some acts are provided for this Article 24 for the security of the women and children to work in any factory in any hazardous materials. Then comes the Article 23 that we have already discussed. Then the Article 24, the prohibition of employment of children. National legislation and the policies against the Child Labor Act. These are some acts to give the protection for the child labor and the mine acts, some like the Child Labor Act 1986, the Prohibition and the Regulations, the Factories Act 1948, the Mines Act 1952, the Juvenile Justice of the Children's Act 2000, the Minimum Wages Act 1948, the Right of Children to Free and Compulsory Education 2009. These are some acts for the child labor in India. Then the Child Labor Amendment Acts. This is the list, the penalties, the schedule, the power of central government, the prohibition of employment, the definition of child is given in this entire table. You can just go with you can read it and get to know about it. That is not that much important. Then right to freedom of religion. The Article 25 in the Constitution of Indian 1949, the freedom of conscience for free profession, practice or propagation of religion, that is subjected to public order, morality, health and to other provisions of this part. All persons are equally entitled to freedom of conscience and the right freely to possess, practice and propagate religion. That means if I am from one religion, then I can spread my religion with free profession and practice and propagation. The Article 25 deals with the all persons are equally entitled to freedom of conscience and the right to freely proffer, practice and propagate religions. Article 26 deals with we'll see about it. Article 26 deals with the protects collective freedom of religion. The subject to public order, morality and health. Every religion determination and section thereof shall have the rights to establish the maintain institution for religion and charitable purpose. That means any religion is eligible to establish and maintain institution for only for the religious purpose and the charitable purpose, to manage its own affairs in matter of religion, to own and acquire the movable and immovable property for the religious purpose and the charitable purpose only. To administer such property is in accordance with the law. It has to be in the boundaries of the law. Then the Article 27 deals with the freedom as to payment of taxes for promotion of any particular religion. No person shall be compelled to pay any taxes, the proceeds of which are specially appropriated in the payment of expenses for the promotion or maintenance of any particular religion. Then comes the Article 28, the freedom as to attendance at the religious instruction or the religious worship in certain educational institution. It allows educational institution maintained by the different religions. That means the institution is allowed to give its own education for the public who is want that religious education, established under the endowment or the trust. Then Article 28 again deals with the children, especially school children, should not be the forced to hear spiritual words by prayers. If any religion is getting subsidy from the government, then the religion should not spread their spiritual words in educational sector. Then comes the culture and educational rights. The Article 29 deals with the protection of interest of minorities. Article 30 with the right of minorities to establish and administer education institution. We will discuss it, Article 29 and 30, in upcoming videos in detail. Then there are some writs in Indian Constitution. What is the writ? The writ is a written word from Supreme Court or High Court. That means the orders given in the written form by the Supreme Court or High Court. For the Supreme Court under Article 32 and the High Court under the Article 226 can issue writs. It means the written order. The Article 32 also empowers Parliament to authorize any other court to issue these writs. There are some writs, the types of writs in India: the Habeas Corpus, mandamus, Prohibition, certiorari, and quo warranto. We will discuss them one by one. First one is the Habeas Corpus. That means the Latin meaning of the Habeas Corpus is to have the body of. To enforce the fundamental right of individual liberty against unlawful detention. The Habeas Corpus, Supreme Court or High Court orders one person who has arrested any other person to bring the body to the latter before the court. The Supreme Court or High Court can issue the writ against the both private and public authority. Habeas Corpus in short meaning, that means any person who is arrested has to be bring or brought before the court, and for that given the written letter for it. The Supreme Court or High Court issue this writ Habeas Corpus against any private or the public authority. Both are in this. Then comes the mandamus. Literally meaning of the writs is we command. This writ is used by the court to order the public official who has failed to perform his duty or refused to do his duty to resume his work. Beside public official, mandamus can be issued against any public body, a corporation, any inferior court, a tribunal or government for the same purpose. Unlike the Habeas Corpus, mandamus cannot be issued against the private individual. In short, mandamus is the command given or the order given by the upper legal officer to the lower legal officer, for just command given by this, and it is not applicable for the private individual like the Habeas Corpus. This is the simple meaning of the mandamus. Just remember as we command. Mandamus means. Then comes the prohibition, to forbid. A court which is higher in position issues prohibition writs against a court which is lower in position to prevent the latter from exceeding its jurisdiction or apprising a jurisdiction that is not possessed. is direct inactivity. The writs can be issued only while the proceedings of case are going on. If the court or tribunal has passed final order, prohibition cannot lie. Important facts. Writs of prohibition can only be issued against the judicial and quasi-judicial authorities and can't be issued against the administrative authorities, legislative bodies and the private individuals or bodies. Prohibition means forbid, to forgive it. And it can be only given when the proceedings are going on and not the final order is given, and it is not applicable, can be issued against the administrative authorities, legislative bodies or private individuals or bodies. Then comes the certiorari. The literal meaning of it is to be certified or to be informed. This writs is against the issue by a court higher in authority to a lower court or a tribunal, ordering them to either a transfer of case pending with them to itself or to squash their ordering case. It is issued on the grounds of an excess jurisdiction or lack of jurisdiction or the error of law. It is not only prevents but also cures for the mistakes in the jurisdiction, preventive as well as curative. In 1991, Supreme Court ruled that the certiorari can be issued against the administrative authorities affecting the rights of individuals. It cannot be issued against the legislative body and the private individuals or the bodies. Certiorari means the higher court given an order to the lower court to have the letters or the transfer the pending cases for the for again getting the process of the jurisdiction and fast process of the jurisdiction without wasting any time. Then comes the quo warranto. It means by what authority or warrant. Quo warranto means warrant under which you are getting arrested or whatever it is. The Supreme Court or High Court issue this writ to prevent illegal uprising of public office by a person. If anyone is getting arrested, then he or she has a right to ask for the warrant, and the Supreme Court and High Court issues that warrant for arresting or any other public affairs. It has been given under the quo warranto. Quo warranto can be issued only when the substantive public office or permanent character created by a statute or by the constitution is involved. It can be issued against the private or ministerial office. This writs gives the right to seek redressal to any individual other than the aggrieved person. Then comes the writ jurisdiction of Supreme Court versus the writ jurisdiction of High Court. To only enforce fundamental right, the High Court to enforce fundamental rights but also for other purposes. The territory of jurisdiction through the territory of India and the territory jurisdiction within its territory jurisdiction of only. Supreme Court deals with the entire country and the High Court for the states. Article 32 is the fundamental right. Supreme Court may not refuse to exercise its power to issue its writs. Discretion may refuse to exercise its power to issue writs. Then the Article 31 deals with no person their property will be taken until there is an authority of law, and if it is not done, then they will be recompensated. Article 31 deals with the acquiring any land or property for the public affairs or the development of the country. The Article 31(1) deals with gave the legal authority a permission to take away the property. 2 deals with the mentioned the word compensation without any adjective which made it very arbitrary as in how much compensation would be given. After all this chaos, the 44th Amendment declared the Article 31 along with the 19(1) as a void. It has been cancelled out. And the third cancelled out, as there was lots of chaos in this article. The doctrine of eminent domain. This doctrine says that the government may take any land holding without the owner's opinion and just give him the compensation for it. The savings of the law providing for the acquisition of estates of Article 31A. These are some provisions for the acquisition of the estates of the property. The 9th schedule deals with the states acts and regulation, which deals with the land reforms and the abolition of zamindari system. Also deals with the acts of regulation of the parliament dealing with the other matters. First Amendment Act 1951 added the 9th schedule to protect the laws which are included in it from judicial review on the ground of violation of fundamental rights. However, later Honorable Supreme Court in 2007 stated that the laws included in this schedule after the April 24, 1973 are now open to judicial review. This is given in the 9th schedule. Then the validation of certain acts and the regulations under the Article 31B. In this article, it was ruled out that if any act present in the 9th schedule is inconsistent with the provisions of or which resist any decree or order, will be left on the competent authority to decide if it will continue to enforce or will void. Anything contained in this article will not undermine anything contained in Article 31A. This article provides blanket protection to laws contained in the Article 9th schedule, 11th schedule. It has respective effects. Then the saving of laws given effect to certain directive principles. Some related case, Keshwananda Bharati case versus the state of Kerala. It was ruled out in the case that any law made which is violative of the fundamental rights under Article 368 Constitution can amend these rights only to the extent that it does not hinder the basic structure. In short, Keshwananda Bharati case it says that the basic structure of the constitution cannot be changed. The Minerva Mills Limited versus the Union of India. In this case, the extended portion of the Article 31C was eradicated because it was violating the fundamental right, and also this part was securing DPSP, Directive Principles of State Policy, above the fundamental rights, which should not be done as these rights are paramount. That means fundamental rights are greater than the directive principles of state policy. Then the Article 33 deals with the Parliament may by law determine what extent any of the rights confirmed by the part shall in their application to A. the member of the armed forces, B. the member of the force charged with the maintenance of public order, C. the person employed in any bureau or other organization established in the state for purpose of intelligence or code intelligence, D. the person employed in or in connection with the telecommunication system set up for the purpose of any force, bureau, organization referred to in clause A to C, be restricted or abrogated so as to ensure the proper discharge of their duties and the maintenance of discipline among them. The martial law and the fundamental rights, Article 31, the restriction of fundamental rights when the martial law is in force. There are some restrictions on the fundamental rights when the martial law is enforced in any state on any part of the Indian country or some states. Martial law concept borrowed from the English. The implies the suspension of ordinary laws and the government by the military tribunals. The genesis is the Article 35A bars the non-JNK resident from buying properties. It has been amended. We all know that. There are some rights that are for only the citizen of India, for the foreigner, and both foreigner and the citizen. These are the fundamental rights available to all. That means the citizen as well as the foreigner. The Article 17 and 18 are for the both citizen as well as the foreigner. The 17 deals with the abolition of untouchability and 18 with the abolition of titles. Then the fundamental rights available to both citizen and foreigner except any enemy alliance. That means we know the enemies of the India, they are not applicable to them. The article 14, 20, 21, 21A, 22, 23, 24, 25, 26, 27, 28. These are for applicable for the citizens as well as the foreigner except enemy alliance. Then the fundamental rights available only to the citizens and not to the foreigners. That means if you are a citizen of India, then these rights are for you only. There are 15, 16, 19, 29 and 30. The 15 was prohibition of discrimination on certain grounds. 16 was the equality of opportunities in public employment. The 19 was the right to freedom. There's 6 parts. Then the 29 deals with the cultural and the educational rights, the protection of interest of the minorities, and the 30s, article 30 deals with the right of minorities to establish and administer educational institutions. These fundamental rights are available only to the citizen of India. This was all about the fundamental rights covered in the part 3 and the article 12 to 35 of the Indian Constitution. This was all about it. We will discuss about the directive principles and state policy tomorrow. And don't forget to like, subscribe and share and press the bell icon to get the notification of the new videos. And thank you for joining me. We will meet tomorrow. Thank you.